Fourth defendants, Timaru Police, North Street, Timaru, Area Commander Inspector David Gaskin. On the 24th of July 2007, Mr. Bishop and his accountant David Keys took a list of complaints to the Timaru Police Station with evidence of some very serious allegations of dishonesty that had occurred in the offices of Debtor Communications. The plaintiffs had been told by Miss Bennet's former employer, Brian Stanford Insurance Brokers, that Miss Bennet was known to the police because she had been dishonest with them. Detective Kevin Burns described the first defendant as a white-collar criminal who was hungry for money. Number 3, the detective police, Mr. Burns, did not take a statement from the plaintiffs or the defendant, but recommended the plaintiffs keep her employed and she would make them lots of money. Number 4, the plaintiffs claimed that Timaru police staff failed to take statements of the first defendant who had, amongst other offences, written out a cash cheque from the plaintiff's chequebook and signed it herself. The plaintiffs claimed the Timaru police staff failed to interview and take a statement from the first defendant's son, Scott Bennett, after they had produced some evidence showing he had purchased goods from warehouse stationery and charged them onto Debtor Communications account without their authority. Number 6, the plaintiffs claimed that Timaru police staff failed to take a statement from the defendant's partner, Harry Travail, who gave evidence in the Employment Relations Authority investigation meeting that he had told his partner to hold on to the Debtor Communications office and post office keys until she got paid. Number 7, the plaintiffs claimed that they suffered unwarranted frustration in the fact that all the evidence they were presenting to the police was being totally ignored, and their final decision not to prosecute was based on the opinion of the ERA member who decided the first defendant was innocent of any crime. Number 8, on the 8th of February, the plaintiffs wrote to the Canterbury Area Commander Inspector David Gaskin, asking him to provide them with their personal files and the files relating to the case. Number 9, on the 12th of April 2010, plaintiffs Mr. Bishop called at the Timaru Police Station and reminded Inspector Gaskin that the 20 days required to produce the official information had not been met. Number 10, Inspector David Gaskin showed no respect to Mr. Bishop and spoke to him from behind a security cage with Constable Paul Hampton as witness to the discussion. Inspector Gaskin said he would not deliver the documents to his home. Plaintiffs Mr. Bishop complained to the police ombudsman and the documents arrived by police car on the 13th of April 2010, some 95 days after the official information request. The plaintiffs claimed some of the documents were missing and some had names and addresses crossed out, while others had police reports that were untrue. Sergeant K.J. Merlin wrote in his police report the following statement: I have had previous dealings with Mr. Bishop, and to say he is eccentric would be an understatement. He is liable to take matters as far as he can, as he perceives he is not be dealt with if he sees he's not being dealt with favourably. Number 13, the plaintiffs now claim that the negative attitude of Mr. McAlanes towards Mr. Bishop has been spread throughout the staff of the Timaru Police Station, which is why his complaints have never been taken seriously. Mr. Bishop, plaintiff's Mrs. Bishop, is yet to receive a copy of her personal police file, as she has one as requested under the Official Information Act. Number 15, the plaintiffs seek compensation of $40,000 from the Timaru police officers involved for not carrying out their duties completely, and a further $10,000 from Inspector David Gaskin for not providing official information within the 20-day period required under the Official Information Act. Fifth defendant, Helen Doyle, Employment Relations Authority, Place for Service, Kilmore Street, Christchurch. Unfair treatment. Following advice received by a Department of Labour inspector, the plaintiffs made a counterclaim through the Employment Relations Authority and claimed for damages to their business. Number 2, the counterclaim was for $42,653.99, which included $15,000 in compensation for the worry and stress and that the first defendant had caused within the plaintiff's family. Number 3, in her determination, the fifth defendant dismissed the counterclaim in its entirety without giving a valid reason. Number 4, at the investigation meeting, the fifth defendant elected not to appoint anyone to record notes of what was said by the investigation, so there was no official notes recorded at the meeting. Number 5, the investigation meeting, the fifth defendant permitted a witness, Harry Travail, being partner of the first defendant, to remain in the room for the duration of the meeting, and the fifth defendant ignored this evidence and that the first defendant was holding Debtor Communications post office keys and office keys as ransom for her wages. Number 6. Plaintiff Mr. Bishop claims he had many questions to ask the first defendant, Miss Bennet, but was told by the fifth defendant, Miss Doyle, that he only had a limited time to ask questions and could he hurry up and finish his questioning. Number 7. The fifth defendant, Miss Doyle, permitted the first defendant to leave the room on more than one occasion without being excused, and she was allowed the first defendant to drink a bottle of Coke during the proceedings. Number 8. The fifth defendant delayed her determination for 4 months before dating the 21st of December 2009, giving the plaintiffs just 28 days, including a weekend and public holidays, in which to obtain legal advice and challenge the determination. Number 9. The plaintiffs found it impossible to find a solicitor over the Christmas holiday season, which caused them a tremendous amount of frustration, worry and stress. Number 10. The plaintiffs complained to the Chief Employment Relations about the member's handling of the case, and his reply on the 21st of January 2010, the CEO made the following statement. The regulations do provide the days between Christmas Eve and 4th of January are not to be counted in the 28-day period. Legal advice states that this is not true. Number 11. On the question of costs, the defendant's solicitor did not provide the Employment Relations Authority with any paid or unpaid invoices for their costs, and yet the fifth defendant awarded them. Number 12. The plaintiffs claim that they had been unfairly treated by the fifth defendant, which has caused them tremendous stress and anxiety, which could have been avoided if things had been done more professionally. Number 13. The plaintiffs seek that the original counterclaim be brought before the Employment Court for a hearing, and that they should be paid a further $20,000 for unfair treatment by the fifth defendant. Miss Bennet. No. Sorry, I'll read number 13 again. The plaintiffs seek that the original counterclaim be brought forward before the Employment Court for a hearing, and that they should be paid a further $20,000 for unfair treatment by the fifth defendant, Miss Helen Doyle. Debtor Communications Counterclaim 2010. Sixth defendant, Jeff Goldstein Barrister, Mandeville Street, Christchurch. Deception. The sixth defendant, as a sole barrister who is not qualified to accept instructions to act for anyone other than a solicitor in accordance with the New Zealand Law Society Rules of Conduct Intervention Rule 14.4. Number 2. The sixth defendant took instructions from the plaintiffs and commenced drafting a statement of claim with the name of the documents, but resigned before the work was completed, and then charged the plaintiffs $1,350 for work he was not qualified to do. Number 3, this put tremendous pressure on the plaintiffs to get a challenge filed on time over the festive holiday period. Number 4, the plaintiffs claimed from the 6th defendant the sum of $20,000 for acting for them without legal authority and causing them much undue stress, anxiety and worry. Seventh defendant, Phil Butler and Associates Limited, Mandras Street, Christchurch. Deception. The seventh defendant advertised their services on a website under the trading name of Phil Butler Employment Law in Christchurch, and when the plaintiffs phoned them to make an inquiry, they charged the plaintiff for the phone conversation before they were appointed to act for them. Number 2, the seventh defendant sent the plaintiffs an unauthorised invoice for $318.94 dated the 14th of January 2010, just for 4 days before the 28-day period was due to end, at which time they told the plaintiffs they did not wish to act for them. Number 3, this happened after the 6th defendant, Mr. Goldstein, had also told the plaintiffs he did not want to act for them, and this compounded the amount of frustration, stress and anxiety the plaintiffs were forced to endure over the first festive season. The 2 individuals who were responsible for the stress placed on the plaintiffs are Phil Butler and Carla Jones, and the plaintiffs now claim $10,000 from each person, making the total sum claim from the company of $20,000. The following information appears on their website, which the plaintiffs believe provide misleading information. Phil Butler has many years' experience in industrial and employment relations and is the director of Phil Butler and Associates Limited. While he has been admitted to the bar of barristers and solicitors at the High Court of New Zealand, he does not practice as a lawyer, preferring instead to operate a company providing advocacy and consulting services to employers and employees alike. Carla has recently joined the business. She was admitted to the bar as a barrister and solicitor of the High Court of New Zealand in 2008, but has chosen not to take out a lawyer's practicing certificate, but is instead practicing as an employment advocate.